Mr. Kimberly.
Thank you, Your Honor. May it please the Court, my name is Kimberly, and I represent Express Scripts and information. Your Honors, if
You
I
need
may,
to speak up, though, please.
certainly. If I may, I'd like to start with jurisdiction, since the Court posed that question in its request for supplemental briefing. On that score, as my friend Mr. Whaley was noted in his statement of conference, we do not oppose the 1653 motion to amend pleadings to state jurisdiction under.
Now, you're going to have to speak up, because I have good hearing, but you're turning into, I can't quite hear you.
Okay, I'll speak better.
That's better.
So we do not oppose the Section 1653 motion to amend the pleadings on appeal to satisfy Section 1332 diversity jurisdiction. In our view, if the Court grants that motion, we are satisfied that. Are you having trouble?
No, I'm fine. I'm fine. I was just.
Pam, can you turn that on? You're just not.
I'm sorry, I feel like
projecting.
I'm
I mean, this poor fellow last time was extremely deaf, and we could hear him fine. I don't
I'm
know.
not sure what the issue is.
Yeah.
I'll try to speak even louder. So, again, 1653, if the Court grants the motion, our position is that we've satisfied ourselves that the allegations are made in good faith and that is sufficient to establish diversity jurisdiction. I think if the Court agrees on that front, then we can avoid the question, the much more complicated and difficult question of federal question jurisdiction under Section 1331.
Pam, I'm sorry to interrupt. Give him 3 more minutes, because the clock apparently kept running while the sound fellows were here, so.
I see.
All right, there you go.
So if the Court has no questions about jurisdiction, I'll just move on to the merits if I may.
Standing, I think standing. So the idea that under the Louisiana statute, I think I've got the statute here, 22:1860.1. I thought Express Scripts was arguing that there's no implied cause of action for private parties, and does that impact standing?
It does not impact standing as we understand it, Your Honor. The availability of a cause of action under state law is a 12b6 issue. It's not one that we've pressed either below or before this Court, before the supplemental briefing. It is our position that there is no implied cause of action, but in candor, I have to acknowledge that there is a chance that the Louisiana state courts would disagree with us. We are asking for a dismissal of the complaint, and we've elected instead to ask for a dismissal on the ground simply that there is no that there is preemption, and therefore that LIPA in this case is simply not entitled to the declaration that it has sought. And it is, if I may, so just to be clear, I don't think then that's a question of standing.
Okay.
It's a question only of the merits.
All right.
And it is on the merits that we're asking this Court to rule just on the underlying preemption question. On that front, Your Honors, I think it's helpful to understand the distinction between Medicare Part B and traditional Medicare, to understand the crux of the preemption argument. Medicare Part B, which is akin to Medicare Part C, Medicare Advantage, is a purely federal health benefit program, and it is funded with federal funds, much like traditional Medicare. But it differs from traditional Medicare in that it is semi-privatized, and that it depends then on competition among the private companies that partner with the Centers for Medicare and Medicaid Services. And with respect to Part B, those are called plan sponsors. Now, what this means under this program is that Congress has decided that with respect to Medicare Advantage, decisions about what benefits to provide, at what levels, what networks to provide, again, at what levels, are all decisions to be made by these plan sponsors rather than by regulators. It is by giving these plan sponsors leeway under this program, free of minute regulations, that these programs then are able to innovate and to create programs and plans that are attractive to consumers and that are cost efficient. If they were regulated in the finely detailed ways that traditional Medicare is, they could The so-called non-interference standard, which is the crux of our briefing and theory in the case, is essential to how this scheme works. And if I could, I'll just recite that provision very briefly. This is W24A63, and it specifies, quote, in order to promote competition under this part and in carrying out this part, the Secretary may not interfere with the negotiations between pharmacies and prescription drug plan sponsors. It also may not require a particular formulary or institute a price structure for the reimbursement of covered drugs. Now, it is through that provision that Congress gave these plan sponsors the leeway that they need to develop cost-effective and substantively attractive plans for consumers. But this scheme would be turned entirely upside down under LIPA's reading of this provision and the preemption provision. In their view, this decision to cordon off this area where CMS may not regulate negotiations of plan contracts is in fact an invitation for states to regulate in CMS's stead. And that would entirely upend the program. It would make it a program regulated principally by state regulators rather than federal regulators.
Is this express, implied, or field preemption?
Well, our position, Your Honor, is that it is express preemption adopting a field preemption standard. And I think that we get this...
What's your case for that? Good grief. I mean, preemption's complicated enough without that.
Well, it's respectfully, Your Honor, it's not a case. It's just the language of the statute. The statute says that the standards...
But it says the Secretary shall not do this, right?
Well, the non-interference standard is a standard applicable to the Secretary.
The Secretary.
But again, to read that as creating a void where state regulators would be free to fill it in would transform this not from a program that allows plan sponsors free of minute regulations to innovate. Rather, it would be a handing over of regulation to state regulators. And on the face of the preemption provision, we know that can't be right, because it says that the standards established under this part shall supersede any state law or regulation with respect to MA plans. We know that the standards established under this part appear in the same provision 2 paragraphs earlier, which says the Secretary shall establish by regulation standards for Medicare Advantage organizations, that's incorporated also against plan sponsors for Part B, consistent with and to carry out this part. The idea is Congress gave to the Secretary, and by delegation CMS, authority to establish this program, and then provided that state laws are not to apply with respect to MA plans. That is the language of the statute. And again, there's no way to make sense of the non-interference standard except as interpreting it and understanding it as a standard under the part applicable to state regulators as well. Else, it would be an allocation ultimately of regulatory authority to the states. And if I may, Your Honors, the CMS itself has addressed these issues, and I'll read very briefly, if I may, from 70 Federal Register 4,319. This is in lawmaking after enactment of this broader preemption provision, where CMS states, although Congress included broad preemption rules in the Act, we do not believe that Congress intended for each and every state requirement applying to be null and void. Rather, in areas where we have neither expertise nor authority to regulate, we do not believe state laws should be superseded. So, for example, environmental laws governing private contract relationships, tort laws, labor law, civil rights laws, and similar areas would continue to apply to Medicare Part B sponsors. This is not a wiping away of all regulation. It is only the wiping away of regulation where, quote, our federal standards preempt state laws in the areas where Congress intended us to regulate. And that includes with respect to what sorts of costs and expenses have to be reimbursed. So I would say that a standard is a federally determined rule or specification or qualification under the MA plan, and that the field then is the area where CMS has been tasked by Congress with adopting standards that govern either MAOs under Part C or plan sponsors under Part B.
Just to be hyper-technical, what status do we attribute in administrative law terms to CMS's statement here? Is that like our deference or something?
I think our deference would be appropriate.
Whatever's remaining of our deference, okay.
Yeah, well, fair enough, Your Honor. I will, so this isn't the preamble to a rulemaking. I think it's fair to say it's an interpretation of the rules in terms that CMS adopted. And I will say also, Your Honor, this is a portion of the preamble to that rule on which my friend on the other side also relies. Nobody is arguing that this isn't the appropriate way to consider Medicare preemption here. Turning then to the reimbursement provisions themselves, the reimbursement provisions are on their face expressly regulations of the contracts between Part B sponsors or their agents here, PBMs. Express Scripts is a pharmacy benefits manager contracted by Medicare Part B plan sponsors. It states, any fee authorized and imposed pursuant to this section shall be considered an allowable cost for purposes of insurance or reimbursements. That is plainly, as applied to Part B plans, it is plainly a state law directing Part B plan sponsors administering a federal program, spending federal money to reimburse a state fee. That is preempted by the express preemption language we submit. So too of 46, 26, 25A2B, which is the next provision under the reimbursement provisions, which specifies that every contract between a pharmacy or pharmacist and a health insurance issuer shall include provisions requiring the health insurance issuer to reimburse the pharmacy for this provider fee. This too is very plainly a interference with the negotiations between plan sponsors and the providers with whom they contract. It's specifying that they must contract in particular ways. I would add that this upends the Medicare program in other ways, because CMS is tasked with determining whether contract terms between plans and providers are reasonable and relevant. That is already an area that CMS exercises exclusive federal authority in. Here, in effect, what the Louisiana State Legislature is doing is it is effectively overriding any federal supervision of the relevance and reasonableness of provisions. In effect, it's to say it is unreasonable not to reimburse this provider fee. CMS has no authority if this fee, if the reimbursement...
Is a sales tax permissible on these drug sales?
Not under Part B, Your Honor. I do not believe so.
I mean, I believe Louisiana imposes sales tax on drugs, doesn't it?
Truthfully, Your Honor, I don't know. The reimbursement system at the point of sale is complex, and I'm actually not sure that they do.
Well,
My friend on the other side.
suppose it did. Would such a sales tax be preempted by the regulations you're talking about?
I believe it would, Your Honor, for the same reasons. Again, this is a federal program funded with federal money. This is subject to exclusive federal supervision. Just like states cannot tax the federal government and federal spending in other respects, I would expect that they couldn't do so here. I would add that the purpose to which this fee is put is yet another reason to find preemption here, because it is used to fund Louisiana's, the state's contribution to the federal Medicaid program. The federal Medicaid program specifies that states must contribute anywhere between 20 and 50% of Medicaid program expenses, and they must do so by levying fees and taxes against healthcare providers within the state. In effect, to allow Louisiana to assess this fee against Part B plans would in effect allow it to collect its share of Medicaid funding from the federal government under the Part B plan. again, that I think is very hard to square with the scheme for Medicaid spending and Medicaid funding, rather, let alone the Medicare Part D program, which again is a program by which Congress determined that decisions about what should be covered are supposed to be determined by contract negotiations and market forces free from regulatory interference, and not by invitation of states to fill in where federal regulators are prohibited. Your Honors, if you have no further questions, I'm happy to reserve the balance of my time for rebuttal.
No, sir, thank you.
Thank you.
Mr. Whaley.
Good morning, Your Honors. J.R. Whaley on behalf of the Louisiana Independent Pharmacy Association. We, LIPA brought this action to seek the declaration that under state law, Express Scripts must reimburse LIPA's members the 10-cent fee imposed on every prescription drug sold in Louisiana. We brought this action after Express Scripts informed our members that it would no longer pay that fee, and that's the genesis of this tech action. Before we get into the crux, I would like to touch the jurisdiction of the standing.
Yeah, my standing question. I apologize. It was confused. I had misread the roster of attorneys there, and I meant to ask you the standing question, not him. But that's okay. He did well avoiding that nonsense. Yeah.
Mr. Kimberly did a good job.
Yeah.
But I do recognize that it's a jurisdictional
Right.
Issue, and you have to be satisfied yourself. And here's the answer, Judge. Under 462625, as Mr. Kimberly said, each contract is essentially, this fee and this reimbursement requirement is essentially inserted into each of those contracts. He and I agree on that. As a result of that, every member would have a breach of contract claim against ESI for its failure to reimburse that fee. And then, under the concept of associational standing, LIPA has the right to seek this declaratory action on that contract term. And most importantly, Judge, and this, I think, covers a lot of this argument, is that each contract in Louisiana, regardless of payer, is likewise subject to 2625. And the individual members' contracts are all identical. And in fact, all pharmacies under the law contracts are identical as a result.
Okay. All right. Thank you.
And if I did want to get into the standing and jurisdictional issues, and if there is no need for me to also cover the motion to amend to assert 1332 jurisdiction, I'll jump into the crux of the Medicare issue. The statutes at issue are not preempted either expressly or through ESI's admittedly novel preemption analysis. And that's because the preemption provision itself talks about, and this is under 42 USC 1395 W26B3, it says, these standards established under this part shall supersede any state law or regulation other than state licensing laws or state laws relating to plan solvency with respect to Medicare Advantage plans, which are offered by Medicare Advantage organizations under this part. So the question for the court, as it was for the district court, is what is a standard? The Ninth Circuit in the case, the Eighth Circuit in the Whaley case, both said that a standard is a statutory provision or promulgated regulation. The Eighth Circuit in Whaley said that Medicare Part D, quote, does not preempt all state laws as applied to Medicare Part D plans. It, quote, preempts only those state laws that occupy the same place, that is, that regulate the same subject matter as federal Medicare Part D standards. And that's on page 971 of the Whaley decision. The Whaley court continued that The state laws are preempted if and only if they either regulate the same subject matter as the federal Medicare Part D or otherwise frustrate the purpose of a federal Medicare standard, and that's under 972. If we use the WEB standard, even under that, what I would suggest would be a more loose interpretation under the preemptive statutes and the preemption law. These statutes are still not preempted. And that's because Louisiana's reimbursement statute doesn't implicate any standard. We have to keep going back to what is the standard that allegedly preempts, either expressly or field preemption through express analysis. And the only two that ESI identifies is the non-interference standard. And Judge Jones, to your point, that standard, as written by Congress, specifically states that the Secretary is prohibited from interfering with the price negotiations between the drug manufacturers, pharmacies, and key plans. Even if this court were to say Secretary doesn't mean Secretary, Secretary means states, Secretary means something else, the Louisiana reimbursement provision still has no bearing on the negotiations between the pharmacies and the PDP plans. It does not mandate the amount of reimbursement or impose a price structure. It simply establishes a fee of 10 cents per prescription that all insurers and PBMs have to ultimately pay. An analogy that I'd like to suggest is one in which, assume that for purposes of this hypothetical, the Louisiana legislature says, you know what, on every car that's sold in the state of Louisiana, you car dealer are going to remit $10 or $100 to the state highway transportation fund to help build highways. But we're also going to add that as a fee that the purchaser has to pay in addition. There would be nothing problematic. There would be nothing wrong from a purchaser going to a dealer and say, look, I know that I'm obligated under state law to pay you the $100 or to reimburse you the $100 that you have to pay for our highways. But I'm not going to do that. I'm going to pay you X number of dollars, and we are going to contractually agree on that agreement. In the same way, there's no prohibition when they're negotiating a dispensing fee or even a price of a drug, which is what the non-interference standard talks about, is the price of the drug, the dispensing fees, the formularies, things of that nature. There's nothing wrong in our analysis, and if this court were to find no preemption, that would obviate the concerns that Mr. Kimberly expresses about this lack of competition. Likewise, because each contract in the state of Louisiana is imbued with this, everyone is on the same level playing ground as a starting point. And again, there's nothing to prevent that negotiation back and forth during that between the plan sponsor and the pharmacy. There's not a one-size-fits-all uniform contract when it comes to drug prices or dispensing fees. It's not as if the Medicare plans say, this is what we're paying all the pharmacies, and this is what we're going to pay for certain drugs. That is a negotiation, and there's nothing wrong with continued negotiation in that point. Judge Jones, you are correct. It's not in the record. It's not in the briefs. But unfortunately, Louisiana, I think, is one of the one or two states in the country that does charge taxes on prescription drugs. Again, not in the record, but as an officer of the court, I'm certain that as Lycos Counsel, if our members were not being reimbursed taxes on Medicare plans, I would certainly have heard about that. And also in the letter that is attached to our complaint initially, ESI doesn't mention, and we're not reimbursing taxes as well. So I just wanted to address that factual question. And again, not in the record and not in the briefs.
Right.
Secondly, Express Script argues that Louisiana's fee provision overlaps with either what's euphemistically called the any willing pharmacy, any willing provider, and or the reasonable and relevant standard, which is under 42 U.S.C. 423-505. All that standard does is requires PBMs to admit into their networks any pharmacy willing to accept PBM's terms and conditions for network participation. Again, there is not a one-size-fits-all as it relates to the dispensing fees paid to participate in pharmacies and for drug reimbursement costs. And so there's no overlap. The Louisiana fee reimbursement provision has no bearing on which pharmacies a PBM may or may not admit to its networks. And most importantly, under 462625A2B, this provision applies to all Louisiana pharmacies. Undeterred with that, however, Express Script argues that the law limits the terms and conditions that PBMs may set for network participation. But the Eighth Circuit in Whaley rejected a nearly identical argument. In Whaley, the PBMs argued that Part B preempts any law bearing on the relationship between PBMs and pharmacies by, quote, limiting the terms and conditions that PBMs can bargain for when contracting with pharmacies. The Eighth Circuit disagreed. Among other things, the court found on page 973 of the Whaley decision that CVS recognized that a PBM's terms and conditions must reflect, quote, minimum standards for pharmacy practice as established by the states. They gave a Code of Federal Regulations cite there. Also, the Eighth Circuit said CMS left it to the states the specifics of what plans a PBM may or may not demand of pharmacies. So simply put, the 10-cent Louisiana provider fee that ultimately imposes on PBMs has no bearings on the terms and conditions that PBMs can set for their own network participation. And as a result, there's no overlap, even under the more loose preemption standard of Whaley, that the Louisiana fee provision and Medicare's indwelling pharmacy provision. Finally, I would just like to address the issue of Medicaid that my friend Mr. Kimberly brought up, and of course we brought up in our briefs and have brought up in the petition. There is an allowance by CMS that a state plan for its Medicaid program can exclude Medicaid and Medicare from its plan. I believe that we have cited that in a couple of places. Louisiana chose not to do this. We say CMS, it's truthfully CMMS, the Center for Medicare and Medicaid Services. And so the requirement for any state plan amendment for a Medicaid program is that it be uniform and broad-based, with the exception that CMS allows you to say, look, we're going to exclude Medicaid and Medicare. Louisiana didn't do that under their state plan amendment. And that state plan amendment has been approved, and the 10-cent provider is certainly part of that funding mechanism. And so if that is not an express approval, then certainly that's an implied approval by CMS of the structure of Louisiana's plan.
This is very complicated, and we don't have that many questions. So what you're basically asking us to do is rely on the Eighth Circuit's analysis. Is that fair or not?
Not necessarily.
Because they don't totally support your position.
That's true, Judge Jones. I think that even under the Eighth Circuit analysis, and again, this Mr. Kimberly admitted, this is a novel interpretation that he doesn't have a case to cite to. So even the cases that I'm citing to, I don't necessarily like all that much. But at least under the Whaley standard, even if you used the standard itself, that the result nevertheless will be that there is no preemption here. I
See,
think-
my hypothetical about sales taxes was, if there were provision in Louisiana law requiring some kind of reimbursement of the sales taxes, would that, under his argument, would that be preempted?
I think under Mr. Kimberly's argument it would be. I don't, and I think he says the same thing, and I tend to agree with that. Again, I don't believe in practice that is, I believe that those are being reimbursed in practice. But nevertheless, I think it's a situation where even in that situation, the question is that it still should not be under our analysis. And you asked about the Levy case. You know, I think that this court can come to the same decision that the district court did, and that, you know, the standard says what the standard says. It's not our role to do that. And Judge Kane said, in the Fifth Circuit has not approved a field preemption analysis under Medicare, and I think his essential response was, and neither am I. Unless there is some stronger rationale than a novel preemption approach, this court can do the same.
Okay, thank you very much.
Thank you, Your Honor.
Mr. Kimberly.
Yes. Thank you, Your Honors. And I will do my best to simplify what is admittedly a complicated area of law. I'll start by asking a question, and that is simply, under the non-interference standard, could CMS promulgate the same kind of regulation that Louisiana did here, dictating that Part D plans must reimburse certain expenses, no matter what those expenses are? And the answer is self-evidently no. That is the entire point of the program, is that it allocates responsibility for determining what shall be covered under what terms to plan sponsors. And then whether or not those decisions are good ones as a matter of policy is up to the market to determine. If plan sponsors don't put together compelling, attractive plans that consumers like because either they're not generous enough or the networks aren't large enough or what have you, the market will speak, no one will sign up for them, they'll sign up for other plans instead. Right? That is how this program works. That's its organizing principle. So there is no question that CMS could not promulgate the same sort of regulation that Louisiana has adopted here. Now, Mr. Whaley's position is to say, well, the non-interference standard applies only to the secretary and not to the states. That's true, but to say that the non-interference standard would have to say, and the secretary shall not, nor shall the states, would make the express preemption provision here superfluous. It's the whole point of the very broadly worded express preemption provision here to make clear that Congress's view is that this is a federal health benefit program subject exclusively to federal regulation and not state regulation. By the lights of LIPA, every provision would have to say the CMS shall, and so shall the states. CMS shall not, and neither shall the states. But again, that would make, it would render the preemption provision here effectively pointless. Can a state require CMS to fund its own contributions to the Medicaid program? And I would say that, just think about that again. Can a state require the federal agency responsible for the federal government's contributions to a state's Medicaid program to reimburse the fees that the state charges to fund its share of the program? That also makes no sense.
Well, frankly, there's a lot in this law that makes less than obvious sense.
Well, respectfully, Your Honor, I do understand that it is a complicated scheme, but I think this most straightforward answer is just to give heed to the plain text that Congress used.
Let me ask you a question. Isn't there a case pending before the Supreme Court this year that's going to raise some broad questions about the theories of preemption?
Well, I'm aware of a cert petition pending in an ERISA case. I'm not aware of,
Is that what it is?
I'm not certain, Your Honor.
Okay, well, I don't follow these things explicitly. I thought I saw a notation about some case like that, but.
Well, I will say preemption is, as you noted at the outset, there are many different versions of it. What we have here is express preemption. What we know after this case, this court's decision in Dialysis Nuco and the Supreme Court's decisions in U.S. Chamber and Franklin Trust is, in a case where you have express preemption, you're just going to look at the statutory text. And here the statutory text could not be more embracive. It says that the standards adopted under this part shall supersede all any state regulation with respect to MA plans. It doesn't get broader than that. I'll note also one final point. Everybody agrees that this preemption provision adopted in 2003 broadened the prior version that had prevailed. And that prior version comprised two parts. The first part said that the standards established under this part shall supersede any state law inconsistent with. But it had a second part as well. And that second part, and so we acknowledge that was conflict preemption. Now we know we're beyond conflict preemption with the present provision. But the 2002 provision also said that state standards relating to the following areas are superseded. And one of those was, quote, benefit requirements. This is, in effect, a benefit requirement. It's saying that a particular fee must be reimbursed as part of the benefit. Even before this 2003.
That doesn't make any sense. The benefit is what the patient gets. This is passed through to the pharmacy.
Well, the pharmacy must remit it, but just like it must remit a sales tax. So
I think you're still playing havoc with the language there.
Well, I think the question of what a benefit is what's reimbursed. That is the definition of a benefit. Now, maybe the pharmacist would decide to incur the cost him or herself rather than pass it on to the participant. But if it's reimbursed, it's part of the benefit.
Well,
I've exceeded my time. Thank you.
Thank you.
No, I just have one other question. What's your position on the Whaley case?
Thank you. I appreciate the opportunity.
Because we endeavor not to create circuit conflicts, and that would be particularly unwholesome in this area.
Absolutely, Your Honor, and we are not asking the court to do anything of the like. So, to start, the Eighth Circuit in Whaley adopted field preemption as the applicable standard. It said, we see this language. Congress was attempting to adopt field preemption as the standard. None of the provisions that it then applied that standard to had any resemblance to this sort of provision requiring reimbursement of particular things. My friend on the other side focused on things like qualifications for admission into a network. I mean, that's a completely different kind of regulation. What the Eighth Circuit had to say about those kinds of regulations has no bearing whatsoever on the question whether a state can require Part D plans, again, federally funded Medicare plans, to reimburse a state fee. And I am quite confident that if this provision had been present in Whaley, the Eighth Circuit would have said that it too is preempted, along with the number of other provisions at issue in that case that it held preempted.
Are there any other circuit cases that we need to pay particular attention to?
Your Honor, I would point you to First Medical. It's a 2007 case out of the First Circuit. We cite it in our briefs. It recognizes, as we've been arguing all along, that the federal and it says so in express language, that the federal Medicare Advantage and Medicare Part D program is an exclusively federal program, subject exclusively to federal regulation, and state laws are not to apply.
All right, sir. Thank you very much.
Thank you, Your Honor.
Thank you.
Concludes our docket for the week. We are